Involuntary manslaughter is an accidental killing that can be committed through criminal negligence. But when does conduct rise to the level of criminal negligence? Virginia's highest court faced this question in a 2010 case involving daycare gone wrong, Noakes versus Commonwealth. Elizabeth Noakes ran a daycare center from her home. For a few weeks, Noakes had been watching 15-month-old Noah Colassaco, who had a habit of standing in his crib and crying while the other children napped. Noakes knew that Noah would fall asleep if he just stopped standing, so she came up with a plan. First, Noakes covered his crib with a padded piece of cardboard. Then she placed a collapsed dog crate, which weighed about 33 pounds, on top of the cardboard. After confirming that the makeshift cover was stable, Noakes left to do housework. 3 hours later, she returned and found Noah unconscious. He was standing with his head and neck trapped between the makeshift cover and the side of the crib. Noakes was ultimately unable to revive Noah, and he was pronounced dead at the scene by emergency responders. The Commonwealth of Virginia charged Noakes with involuntary manslaughter, and she was convicted after a bench trial in state court. The trial court concluded that Noakes acted with reckless disregard for Noah's safety and the consequences of her actions by proceeding with her plan to keep him from standing. The Intermediate Appellate Court affirmed, upholding the trial court's conclusion as reasonable and observing that the consequences of placing the makeshift cover on Noah's crib were foreseeable. Noakes appealed her conviction to the Virginia Supreme Court, arguing that she wasn't criminally negligent and that Noah's actions in the crib were an unforeseeable intervening cause of death that relieved her from liability.